Welcome to Shenkman Education. My name is Marty Shenkman, and the topic for this video clip is planning for LGBTQ community. Very important that you address planning proactively. A married couple has all sorts of default laws built into the statute that if you don't have a will, your spouse inherits. If there's a divorce or a breakup of the marriage, there's rules for how assets get divided. If you have a significant other and you're not married, none of those rules apply. You can't avail yourselves of any of those protections. So what you don't plan is really going to be unplanned. So it's very important to be proactive. A common issue that can arise is if you are sick, you want to provide a healthcare proxy. It's a document in which you appoint an agent to name your partner, significant other. If you're married, your spouse. But if you're not married, it's really important to do that so that somebody that you care about and that cares about you will have the ability for visitation, and for decision making it should really be in the healthcare proxy that you name that person, but you should also indicate that for visitation purposes you wanted them treated like family, like a spouse. Another consideration is how do you address the myriad of different issues that can affect you in the planning. And I'm going to give you a concept that is new and novel, hasn't really been used much, but can really be a very big help to protecting you or your family members, your loved ones. What happens if there's a change? The wind's a little more than I thought in this. I thought it was a good backdrop. What happens if somebody transitions? What happens to their inheritance? What happens if a same-sex couple has a child? Will the definitions and manner in which a will or a trust that someone else created to benefit you or your descendants, will it really work? In a lot of cases, it won't. And how do you deal with a change in names? Somebody may change their name. You don't want them referred to by their dead name. They may not want to be referred to by that. What happens if there's a name change? Is it the same person? If somebody has in their will, I bequeath my gold watch to my son Joe or to my eldest son, and the son transitions or changes their name, is it the same person? Yes, and they should inherit, but is that what's provided for legally? It may not be. So here's the concept. In estate and trust planning, there's a concept called a trust protector. A trust protector is a person who can act in a fiduciary or non-fiduciary capacity and is given certain express powers. The most common powers given are to change trustees. I didn't plan this well. Change trustees, change situs and governing law, remove and replace a trustee, things like that. But that same concept of a trust protector can be sort of melded with another concept called a limited power of appointment, which I'll explain and then tell you how you work them together and why this can be such an incredibly valuable planning tool for those in the LGBT community or for people who are bequeathing assets to heirs, whether children or other heirs that are members of the community or maybe. So a limited power of appointment is you can give somebody, it's usually in a non-fiduciary capacity, the power to appoint assets that are under your estate or in a trust. And that power is typically limited, so they can't appoint it to their creditors or to themselves or the creditors of their estate or their estate. It's called a limited power of appointment. So if I create a trust for my wife, I could give her a limited power of appointment to appoint amongst anyone she wants. Or I can limit it to family, or I can limit it to kids or descendants or anything like that. So it's a power to direct where assets go. If you designate somebody as a trust protector, and not a general trust protector necessarily to change trustees and change situs and governing law, but a trust protector with special powers to address the types of issues that may arise for an LGBTQ heir, such as transition, name change, etc., they can then determine who is an heir, who's not an heir, who should receive the gold watch from my prior example. Giving them a limited power of appointment also gives them the legal right to direct assets there. So let's say you're in a same-sex relationship, you have a child, the child doesn't meet the definition of descendant under the document. The trust protector could appoint assets to a person that you've treated like a child. The problem is that a lot of the definitions, law, state law default statutes that apply if the document is unclear or silent, don't fill in all these gaps now. So that's a way to address it. So you need to be very proactive in intentionally and thoughtfully planning for your family or for LGBTQ heirs, and a creative way that you should talk to an attorney. It's a complicated concept, you're not getting it in online forms, is to create a special trust protector role, could be an LGBTQ trust protector, whatever you want to call it, and couple that with perhaps a limited power of appointment to give a person you trust and a successor the authority to act in a way that can protect your wishes. Thank you for joining me, and please keep in mind that all the information on the video clip is for educational purposes only. Don't take any action without consulting appropriate advisors. For more information, see shenkmaneducation.com. Thank you.